So in the UK GDPR and indeed the EU GDPR, the legislation refers to data protection by design and by default. And that means tech businesses need to take appropriate security measures to make sure that their tech products are keeping personal data secure, and also that both in their tech products and indeed in their businesses, they are only collecting and using personal data to the extent it's really necessary for performing the specific purposes that are being pursued. It's also really important that tech businesses keep in mind at all times the data protection principles. Now, there's 7 of those. I'm not going to go through them one by one, but right at the top of the list is the principle that processing personal data should be done lawfully, fairly, and in a transparent manner. So basically, there should be no surprises when it comes to tech businesses and their use of personal data. So as a tech business, you need to tell me what personal information about me you're collecting and using, and tell me why you're using it. So what's the purpose for that? What lawful basis applies under the legislation? Tell me who you're going to share my personal information with and whether it's going to transfer outside of the UK, and tell me, how long are you going to keep my personal information for? So the regulation of AI feels like it's one of those areas where the law is desperately trying to play catch up with the technology. In the EU, they've implemented the EU AI Act, which applies different rules to different risk levels of AI systems. So that EU AI Act talks about unacceptable risk AI systems, which are largely banned. And so an example of an unacceptable risk AI system would be an AI system that's designed to influence cognitive behaviour, so cognitive behavioural manipulation, which just sounds like a bad idea, really, doesn't it? Then the legislation also talks about high-risk AI systems, and an AI system might be high risk because it's used in a product that falls within the EU's product safety legislation, or because of the sort of area in which the AI system is being used. So AI use for law enforcement or in education are both seen as high-risk AI systems. In the UK, position's slightly different. So the regulation of AI is essentially done through intellectual property laws, data protection laws, consumer laws, and contract law. The key, I think, for tech businesses with their AI systems in the UK is making sure that they're tracking and able to explain what data and content has been used to train their AI systems, and making sure that they've got the necessary permissions for use of that data and that content for that purpose, for the training of the AI. So tech businesses need to be very much aware of what rights need to be registered in order to be able to prevent unauthorized use of your tech, of your intellectual property, and prevent other people benefiting from your creation without any benefit to you.